Admission, item 2.
Okay, you have filed additional affidavit also?
Yes, my lord, we filed 2 additional affidavits.
2 additional affidavits?
Yes.
October, 6 June. One was in 23, one is in 24.
Correct, my lord. So the first affidavit, my lord, was basically, my lord, some RTI replies.
Alam, you may go. It'll take some time. You may go. Yes, what is your case?
So, my lord, in this case, we are basically concerned with the recruitment of the respondent number 5.
Number 5.
Yes, my lord. To the
As-
post as superintendent in the NIT, my lord.
Superintendent.
Yes. My lord, I'll quickly give your lordship a sketch of what I'm going to argue, my lord.
Yes.
My lord, my first argument is going to be, my lord, that he is overaged. Basically, my lord, he is overaged on the date of the
What is this post of superintendent?
superintendent
It's
post.
equivalent to the superintendent post in the government, that superintendent post.
My lord, the nature of the post, I'm not sure, my lord. I'll take your lordship to the record, my lord. I'll take your lordship to the rules of the recruitment rule itself, my lord.
Now, what is the manner in which the posts, what posts are available under NIT?
My lord, NIT has many posts, my lord. One is teaching and non-teaching. my
And
lord.
this will be non-teaching?
Non-teaching post. my lord.
Superintendent?
Superintendent. And it's a Group B post. And the pay scale, my lord, as per the rules is within the pay band 2. They come in within the pay band 2. So the pay scale is 9,300 minus 34,800, my lord. So that would be equivalent to grade B post, my lord, in the government service.
Pay band 3?
Yes, my lord. Pay band 2.
Pay band 2?
Yes.
Okay. All right, yes.
So my first argument, my lord, is going to be that he is overaged. And the second argument, my lord, is that he has been given relaxation on the ground, my lord, first that he is a departmental candidate. And the second ground, my lord, he has been given is because he is in the ST, my lord. He has been given two concessions, basically, my lord. So, my lord, my second argument is going to be that this cannot be done simply because once you have enjoyed an ST benefit, you cannot occupy an unreserved post. He has taken the benefit of an ST concession, my lord. So once you take that concession, my lord, because the post we are talking about here today, my lord, it's an unreserved post. It's not made for ST, SC, it's made for everyone, general post, my lord. So once you take that benefit, you cannot occupy this post. That is the second argument. And finally, my lord, I am going to argue that the degree certificate he had submitted, it is not a recognized degree for the purpose of this post. So it's going to be 3 limbs, my lord, my arguments. But before I take your lordship to the argument, my lord, I will first quickly take your lordship to the relevant rule, my lord.
Page.
It's at page 82. Short title and commencement. I'll quickly read this part because, my lord, I think ultimately my learned friend is going to refer your lordship to these portions, my lord. So I'll quickly start from the first. These rules may be called the NIT Non-Teaching Recruitment Rules 2019. These rules shall come into force from the date of their acceptance, adoption by the Board of Governors of the concerned institute. Now that it has been adopted, my lord, it has become into force. Now, number 3, my lord. The method of recruitment and other matters relating to the post of non-teaching shall be specified in the annexure attached to these rules. I will take your lordship to these annexures later. But before that, if I take your lordship to page, number 5, my lord, at page 83.
No, because before that,
Yes.
date of coming into force, what is the date?
My lord, the date of coming to force, my lord, it's in
Date
the-
of acceptance, adoption by the board.
Yes, yes. And it has been accepted. I'll take your lordship there because right now I don't have that date, my lord, but it has been accepted also.
Is it relevant to this case?
No, it's not.
That particular
entire
date,
thing-
whatever.
No, that's not
Okay.
relevant. But, my lord, serial number 5 is relevant.
Savings.
Yes, my lord, page 83. Nothing in these rules shall affect reservations, relaxations of the age limit, and other concessions required to be provided for the candidates. My lord, I would like your lordship to mark required to be provided for the candidates belonging to the scheduled castes, scheduled tribes, other backward classes, ex-servicemen, and other special categories of persons in accordance with the orders issued by the central government from time to time. In this regard, these rules shall also not affect the recruitment already made, but any appointment of promotion proposed to be made or made subsequent to the notification of these recruitment rules will be governed by these recruitment rules. Your lordship will see required to be provided. My understanding of, my lord, required to be provided is, my lord, let's say if the central government makes a mandatory law that says that reservation has to be applicable to certain posts, my lord, that is required to be provided when there is no, when it's absolute, my lord. That is my interpretation. So this part is important, required to be provided, my lord.
Yes.
Yes. So, my lord, I'll take your lordship to page number 161. This is the relevant portion with respect to that post, superintendent. 161, my lord. My lord, number 1, name of the post, superintendent. I will not read the pay scale and all of those things, my lord. They're not very relevant. But serial number 6, my lord. Serial number 6, age limit for direct recruits. That is 30 years. And there is a note which says relaxable for departmental candidates up to 5 years in accordance with the instructions or orders issued by the central government. Now, my lord, my humble understanding is that this relaxation can go on only up to 5 years for departmental candidates. And that has, because 5 years is in accordance with the instructions or orders issued by the central government. This is my understanding of this particular provision, my lord. And educational and other qualifications required for recruitment. Essential, first-class bachelor's degree or its equivalent degree from a recognized university or institute in any discipline, or master's degree in any discipline from a recognized university or institute with at least 50% marks or equivalent grade. Number 2, knowledge of computer application, word processing, spreadsheet. Now, this is basically, my lord, the basic requirement that is relevant for this present purpose, my lord, for the present case. Now, I'll take your lordship to the advertisement that was issued, my lord, which is at page number 201. Page 201. Employment notice for non-teaching post, my lord. The date is 8/7/2022. Lordship will see serial number 2, that is superintendent, and there is one post. And your lordship will come to the next page. which is a continuation of the first page. And your Lordship will see serial number 2, Superintendent Group B, and then Lordship will see age limit. It says not exceeding 30 years. Not exceeding 30 years. Now this was on 8/7/2022. My Lord, just for your Lordship to note, because I will be taking your Lordship to the relevant record afterwards later, but the age of the respondent number 5, the date of birth of the respondent number 5, my Lord, is 13/12/1986.
When?
13/12/1986.
Yes.
Which means on this date, my Lord, he was 35 years, 5 months, if I'm not mistaken, my Lord, 35 years, 5 months, sorry, 35 years, 6 months, and 25 days old on the date of the advertisement. Now, your Lordship will come to page number 204. Your Lordship will see at serial number 7.
Yes.
My Lord, there it says, candidate must attain 18 years of age. The crucial date for reckoning age limit, possession of educational other qualifications, possession of required experience, etc., is the last date of submission of application, that is 6/8/2022. So, my Lord, if we were going to count his age from 6/8/2022, my Lord, he would be 35 years, 7 months, and 24 days old, my Lord. Because we would be adding 2 more months, my Lord. So we would be adding, yes, almost 2, around 1 month. So his age would be older, my Lord, if we were to reckon from 6/8/2022. And my Lord will come to page number 207, my Lord. There's another relevant provision with respect to age. My Lord, it says like this, 25, serial number 25. Age relaxation in different categories shall be as per Government of India norms. So now, my Lord, on the background of this, the respondent number 5 and petitioners, they applied for this post, my Lord. And the respondent, the next page, my Lord, that is the notification dated 21st December 2022. There, my Lord, the name of the petitioner is reflected at serial number 20. That is the name of the petitioner, my Lord. Now, the respondent number 5's name was not reflected in this eligibility list. I'll take your Lordship to his representation that he had filed later, my Lord. So he had filed a representation, and in his representation, he had asked for age concession. My Lord, actually, his representation, I'll take your Lordship now only, my Lord. I think it will become more convenient. My Lord, in his affidavit that he had submitted, in his affidavit in reply of the respondent number 5, my Lord. Now, at page number 56 is his representation, my Lord.
Affidavit reply of?
Affidavit in opposition to the writ petition by the respondent.
Opposition, isn't it?
Yes. My Lord has got it?
No. Still searching for it.
It says, my Lord, affidavit in opposition of the respondent number 5, Sri Lalrin Omakyangte, my Lord.
Come here. Just find out. Affidavit in opposition of respondent number 5. Page number?
My lord, at page number 56.
Yes.
That's his representation, my lord. I'll quickly read, my lord. With due respect, I beg to state that I have applied for the post of superintendent at NIT Mizoram via advertisement number so-and-so, for which I have learnt that my application was rejected after the issuance of the list of eligible candidates via notification so-and-so. Having thoroughly rechecked the application which I had submitted, I could not rule out why it has been rejected. The only probable reason for rejection of my candidature might be on the ground of being overaged. If this is the case, I earnestly request you to please revisit my application referring to the DOPT order on information documents on grant of relaxation of upper age limit, point number 5, 5.2 annexation number 1, which states that age concession of 5 years are allowed to departmental candidates, central government employees, in case of recruitment to Group B and Group A and Group B posts, which are filled through UPSC, other than those filled on the basis of competitive examination, and posts which are exempted from purview of UPSC, where recruitment is made by organization themselves. This concession is admissible to such of the government servants as are working in posts which are in the same line or allied cadres, and where a relationship could be established between the service already rendered in a particular post will be useful for the efficient discharge of the duties post. He has annexed those documents he is relying on. In the meantime, I had also submitted my scheduled tribe certificate for claiming my age relaxation. Therefore, I would be very grateful if you kindly look into my request at the earliest and revert on the same. Now, my lord, the documents he had referred to are from page 57 onwards, my lord. Now, page 57, my lord, this part is quite relevant, my lord. Notes 1, 2, and notes 1 and note 1 is important. Let me quickly read, my lord. It says like this. This document is a compilation of all relevant instructions. My lord will note this part, my lord. Relevant instructions, not rules or orders, my lord. This document is a compilation of all relevant instructions on the subject of relaxation in upper age limit for direct recruitment to civil service, central civil service or civil post, and therefore is intended to serve as the guide without the need for anyone to refer to old OMs issued from time to time. The list of such OMs is given in appendix to this document. In case any reference to the relevant OM is required, the same may be accessed from archive section of DOPT's website. Now, my lord will come to number 1. The other one was Roman 1, now, my lord, normal 1. Instructions. My lord, again, instructions. Because these are all instructions he's relying on, my lord. Instructions allowing relaxation in upper age limit for appointment to civil service post services for various categories of candidates have been issued from time to time. These instructions are applicable only to central government civilian employees holding civil posts and do not suo moto apply to other categories of employees, including employees of autonomous statutory bodies, central public service enterprises, etc. The following paragraphs indicate the relaxation allowed for different candidates, categories of candidates. So this is specifically not applicable to autonomous bodies, my lord. The respondent number 1 to 4, they are an autonomous body, my lord. And your lordship will come to page 59, my lord. This is what he had specifically quoted in his representation.
Which part?
Page 59, my lord. Page 59.
Yes.
Age concession of 5 years are allowed to departmental candidates, central government employees, in case of recruitment to Group A and Group B posts, which are filled through UPSC, other than those filled on the basis of competitive examination, and posts which are exempted from purview of UPSC, where recruitment is made by organizations themselves. This concession is admissible to such of the government servants as are working in posts which are in the same line or allied cadres, and where a relationship could be established that the service already rendered in a particular post will be useful for the efficient discharge of the duties of that post. So using this, my lord, on the strength of this 5.2, his age was relaxed, my lord. Now, at the time of filing this writ petition, my lord, we were not privy of this representation, my lord. But anyway, my lord, that does not matter. So, my lord, when the results came out, so he was allowed to write his exam, my lord. At page 222, my lord, this is the first impugned notification, my lord. This is notification dated 22/2/2023.
What is 208?
My lord, 208, let me go, my lord.
Notification to appear for the exams.
Correct, my lord. This one is, these ones were the list of eligible candidates, my lord.
So between this and this notification, what,
He has filed his representation.
222, representation filed, then examinations conducted?
Correct, my lord.
What is the scheme of the exams?
My lord, instructions to candidates will be there, my lord, at page 212.
No, what all was,
The exam, my lord, the exam
Yeah.
papers. My lord, the exam papers are at page number 214.
it was a written exam.
Correct, my lord. It was
How many
written-
papers?
So they have, my lord, written exams of 2 papers, my lord. Paper 1 and paper 2 is there. So paper 1 involves general aptitude and reasoning, general knowledge, general English, and paper 2 involves word processing, spreadsheet, PPT, my lord.
Then interview.
I'm not sure, my lord. 1 minute, let me check, my lord. I'm not sure there was an interview, my lord, after this.
The advertisement does not spell about the manner in which the selection is to be done?
My lord, the advertisement, if your lordship, my lord, the advertisement talks of,
This is by what? Direct recruitment?
this is direct recruitment, my lord. My lord, the advertisement mentions, my lord, at page number 205. Serial number 16, my lord. The scheme of syllabus for competitive examination, NIT Mizoram, approved and adopted by the Board of Governors, NIT Mizoram, by so and so, for the advertised non-teaching posts are enclosed in annexure number 4. So candidates are advised to scrutinize the details of the scheme of examinations and to prepare accordingly, as per the standing mandate of the Government of India, so and so. So this is the scheme is provided at annexure number 4, my lord. So that annexure number 4, my lord, we don't have it in our writ petition, but it is equivalent to the one that I had mentioned earlier, my lord, that at annexure number 2 of that notification.
So it seems that there is no interview.
There was no interview.
It says that in the order of merit,
Correct, my lord.
on the basis of performance in the competitive
Examination.
written examination.
Yes.
So page
Page-
222,
Correct.
222 is the results.
Correct, my lord. And there, the name of the respondent number 5 is serial number 1. And your lordship will see the bottom. That's the panel list, my lord. There, the name of the respondent, petitioner is reflected, my lord. Is the waiting list number 1. So is the waiting list number 1, and thereafter, my lord, at page number 225.
2 to 5.
Yes, my lord. This is the order of
Appointment.
approval. Yes, correct. And then thereafter, my lord, we came across this document which is at page number 227. Because the respondent number 5, my lord, was a departmental candidate. He had been serving there as a multitasking staff in the NIT. So in his previous appointment, my lord, his date of birth is reflected and his name is at serial number 15, my lord. Lalrin Omakyangte, my lord. There his date of birth is written as 13/12/1986. So we got that document, my lord, and thereafter we also got a RTI, which is the affidavit we had filed, my lord, one of the additional affidavits we had filed. There his birth certificate is also enclosed, my lord, and there is no dispute that his date of birth is the same one as indicated in this list, my lord. That is 13/12/1986. So there is no dispute to that in that respect. Now, but my lord, after we had filed his writ petition, and after this representation was already filed, and after he had been recruited, my lord, in their reply to the affidavit, to our writ petition, my lord, the argument that they have put, which is reflected in their affidavit, if I may read, my lord,
Opposition.
their submission, my lord, with respect to why he has been given this. Because now, even after 5 years of, because your lordship will remember, my lord, he was 35 years, 7 months, so and so forth, my lord. And the maximum relaxation you can have is 30 plus 5 years. And in his representation also, he had asked only for 5 years. So he was 35, he could not have applied, my lord, even if he was relaxed as per the rule that he had relied on, as per that instruction he had relied on.
Okay.
So then in their reply, my lord, in their reply affidavit, this is what they had mentioned, my lord. This is
No, reply affidavit or affidavit in opposition?
affidavit in opposition.
Which page?
This is at page number 4, my lord. Sorry, my lord. 1 minute. I'm sorry, my lord. This is at page number 7. Serial number 5, my lord. That being aggrieved, my lord has got it right. The respondent number 5 had submitted a representation dated 23/12/2022 by way of an email. My lord, I had already read out that email. The respondent number 5 stated that although he did not know the exact reason for rejection of his candidature at that particular time, he presumed it to be on the ground of the allegation that he is over age to apply for the post of Superintendent Group B. If that is the case, the respondent number 5 requested to revisit his application by referring to the DOPT office memorandum number so-and-so dated and so, by which age concession of 5 years are allowed to departmental candidates, central government employees, in case of the posts which are exempted from purview of UPSC, where recruitment is made by organization themselves. Besides this, another DOPT notification, my lord, this was not part of his representation, this besides this part, my lord, this is a new one included by them in their affidavit. Besides this, another DOPT notification number 210172 established D dated 7/3/1974 allowed age concession of 5 years for the scheduled castes and scheduled tribes for the purpose of appointment under the government of India in respect of all posts filled by direct recruitment. Therefore, the claim of the respondent number 5 by way of his representation is that he could avail age concession of 5 years as he is a departmental candidate and also another 5 years as concession as he is a scheduled tribe. So basically, my lord, what he's saying is he got 10 years of relaxation, my lord. And this document that he has relied on, my lord, is at page number 69, my lord. Annexure 7, my lord. Annexure 6. In mine, it's written as Annexure 6. 69, my lord. It's given as.
Annexure 7, correct. No, Annexure 7, not 6.
Okay, my lord, there must be page number 70. So this is what he has relied on, schedule. So it says like this: certain age concessions have in the past been sanctioned to a few specified categories of persons for the purpose of appointment under the government of India. These concessions are still in force until further orders. Details of the categories of persons and age concessions admissible to them are given below, are hereby published for general information. Now he has relied on that serial number 1, my lord, scheduled caste and scheduled tribes, all posts filled by direct recruitment, 5 years.
Is there any clarification here?
Not that I am aware of, my lord.
5 years in the case of, in the relevant in this case, which should be over and above the other relaxation.
That is not mentioned.
It is not mentioned.
It's silent.
Okay.
And my lord has put that point very clear, my lord. So the issue in this case, my lord, when the rules.
So the question is whether he is entitled to 10 years or 5 years, that's all.
Correct. When the
If
rules
it's
are
10
silent.
years, then it's permissible.
Correct.
If it's 5 years, he overshot that by 6 months or 7 months.
Correct, correct. So that is the simple. So, my lord, this is how I frame the question, my lord. Whether this cumulative benefit, my lord, 2 years benefit, two concessions can be availed when the rules are silent. When there is no specific provision that says that you can have 2 years benefit.
Okay. And what about the educational qualification, which you were saying?
Now, the educational qualification issue, my lord, we had raised this using our affidavit, which we had submitted on 26/6/24, my lord. Because your lordship will remember, if your lordship will,
Where in additional affidavit?
yes, because we had filed two additional affidavits. One
which
was
one?
affidavit dated 12/10/23, my lord.
The earlier one or later one?
The later one, my lord. But I think, my lord, will have to look at these two affidavits, because in the first affidavit, just page number, my lord, 1 minute. Yes, my lord, in the first affidavit we had submitted, your lordship will kindly turn to page number 24.
Singhania University.
Singhania University, my lord. Now, if your lordship will see below, this was issued on in December 2018. But if your lordship will see the first, it says like this: this is to certify that Lalrino Makhyangte has completed 5 semesters of aircraft maintenance engineering training in DGCA approved AME training schools. Civil Aviation Requirements Section 2, Airworthiness issued 4 series, E so and so, so and so. Now, my lord, this Singhania University, what it had done, my lord, was, because if your lordship will see the previous pages, the previous page, semester mark sheet, School of Aeronautics, if your lordship will see, it says 6 January 2012, the date of issuing of the first of that certificate. Statement of marks. Lordship has seen it?
What is the date?
Lordship, the date is in the lower box. There are two big box in
Yes,
the
6 January.
yes, date of declaration of results, 6 January. So basically, that was his final results, my lord, in the aeronautics, in one institution, which is not Singhania Institute, my lord, it's another institute. So what he has done, my lord, what has happened is, in Singhania University, Singhania College, my lord, Singhania University, he had done only only 6 months course, my lord.
How do you say that? 6
My
months
lord,
course.
I will. One minute, my lord. Yes, my lord, it's in their affidavit, in reply to this additional affidavit we had submitted, my lord. My lord, at page number 3, paragraph 4.
Which affidavit?
My lord has got it.
Which affidavit?
My lord, they had filed an affidavit in
No.
they had filed an affidavit in reply, my lord, to this additional affidavit we submitted.
Page number 4.
Page number 3, my lord, serial number 4.
How does it begin?
So it says like this, my lord, that in reply, my
Yes.
lord has got, in reply to paragraph numbers 5, 6, 7, and 8 of the additional affidavit, it is veracious to submit that the respondent number 5 had completed the 3 years full-time AME avionics course from the School of Aeronautics, Nimrana, Rajasthan, India, in the month of August 2012. Thereafter, the respondent number 5 had further completed the 6 months course at Singhania University, Jhunjhunu, Rajasthan, India, for pursuing Bachelor of Science degree in Aircraft Maintenance Engineering, for short AME, and was awarded bachelor degrees in AME in 2018. It may be elaborated here that since a large number of AME students, after spending 3 years in AME training institutes, do not get employment, as these courses are not recognized by any government body or degree or diploma, the University Grant Commission, in consultation with the Ministry of Civil Aviation, had introduced a BSc Honours course in AME in order to safeguard the interests of such AME students. In this regard, a public notice, vide file number so-and-so, dated 8/3/2017, and another public notice, vide file number so-and-so, were issued by the Director General of Civil Aviation, wherein what has been stated in the above, along with the template for model syllabus for such BSc Honours course in AME, were published. Pursuant to this, the respondent number 5, who had completed his 3 years full-time AME training course from the School of Aeronautics, Nimrana at Rajasthan, had further completed the 6 months course in Singhania University in Rajasthan in the year 2018, thereby obtaining the degree of BSc Honours in AME. So, my lord, this is how it is, my lord. So in 2012, my lord, he had done that 3 years course, and in Singhania University, he had done 6 months course, and in lieu thereof, my lord, Singhania University, in lieu of the 3 years he had done, had awarded him the certificate of BSc Honours in AME, my lord.
And where is that certificate?
My lord, his certificate is at page number 67
Of
this affidavit itself, my lord.
67.
67, annexion number 5, my lord. They have only annexed, my lord, mark sheet. This is the mark sheet, my lord.
Yeah, this is similar to page
Yes.
24.
Similar to what I had shown your lordship before.
What is the percentage? It's all A plus.
Yes, it says 77 point, sorry.
The required percentage was 50 and above.
Yes, yes.
Either you have the bachelor's degree in 50%.
Now, the reason we are contending this, my lord, is because of, if your lordship, in this respect, my lord, I'll have to take your lordship to the background with respect to courses like this, my lord. Now, if your lordship will come to page number 18 of the affidavit we had submitted on 26/6/24, my lord. Your Lordship will remember he had completed his course in 2012 first, the original 3 years course in 2012. Now this notification came in 8 March 2017, my Lord.
Which notification?
My Lord, at page number 18 of this affidavit we had filed on 26/6/24, my Lord.
What is this?
This is a public notice regarding the course, his course. Public notice. The GCA approves AME training institutes to impart ab initio training in the field of aircraft maintenance. A large number of AME students, after spending 3 years in such institutes, do not get employment since these courses are not recognized by any government body as degree or diploma. The 3 years spent by students in these institutes become unproductive. My Lord will note he had done his course in 2012. In order to safeguard the interests of AME students, the University Grants Commission, in consultation with Ministry of Civil Aviation, had introduced a BSc Honours course in aircraft maintenance, and a template for model syllabus has been published, which is available at UGC website. So only in 2007, my Lord, steps were taken to regularize those kind of courses, to recognize those kind of courses.
17.
17. He had done it in 2012, my Lord. Now the next notification, my Lord, is
Anyway, we'll come back at 2.
yes, my Lord.
You're there, Mr.
Your Lordship.
Okay. Yes, Mr. Joseph.
Yes. My lord, I was presenting the facts regarding the degree of the respondent number 5, my lord. I'll just, my lord, before I go on, my lord, I will just refresh your lordship's memory, my lord. At page number 65, this was something I think your lordship, I had not placed before your lordship.
65
Of the affidavit in reply against the additional affidavit dated 27/5/2024, my lord. Affidavit in reply of respondent number 5.
65.
Yes, page number 65, my lord.
Yes.
So this was the initial degree he had received from Neem Rana University, my lord. And your lordship will see it's written like this. This in the last part, in the last line of the first paragraph. The semester's examinations during the period between July 2009 to 21st August 2012. So the duration of that course, my lord, is from 2009 to 2012. So this was issued, my lord, on 21/8/2012. My lord, the dates are also going to be important, my lord, in my submission. 21/8/2012 is the issuing date of this particular certificate. And my lord, at 67,
67.
67 was the degree issued, was the statement of marks issued by Singhania University, my lord. Page 67. And if your lordship will see, the date for declaring, the date on which the results were declared was on 3/1/2019. These two dates are also going to be important, my lord. 21/8/2012 and 21/8/2012 and 8/1/2019.
How will it be important?
My lord, the reason is because in 2012, when this original degree was given to him, my lord, this particular course, my lord, was not a recognized course.
It became, it was recognized in 2017.
2017
Onwards.
onwards.
It doesn't go back. It doesn't go back.
It
in
doesn't,
time.
there is no retrospective effect, my lord.
Those who have already had 3 years of degree, they came to be recognized in 2017.
Not the degree per se, my lord. Universities, colleges were allowed to offer courses like that from 2017.
Where
Until
is that,
2000.
where is that 2017 thing?
Yes, my lord. My lord,
Page
that
18.
that's in the additional affidavit dated
Public
20
notice.
Yes, my lord. The
Public
first one is the
notice.
public notice, my lord. Public notice. This was on 8 March 2017. DGCA approves MEA training institutes, my lord, to impart ab initio training in the field of aircraft maintenance. A large number of AME students, after spending 3 years in the said institutes, do not get employment, since these courses are not recognized by any government body as degree or diploma. The 3 years spent by students in these institutes become unproductive. In order to safeguard the interests of AME students, the University Grants Commission, in consultation with the Ministry of Civil Aviation, has introduced a BSc course. So they have only introduced a BSc course, my lord, in 2017. In aircraft maintenance, and a template for model syllabus has been published, which is available at UGC website, so and so. So for the first time in 2017, my lord, it was introduced. Because until 2017, it was not recognized.
So what happens after this?
So after this, my lord, another public notice was there. I'll take your lordship to, this is the next page, my lord, page number 19.
BSc honors course in aircraft maintenance.
Correct, my lord.
Then page 19.
Page 19, my lord. Now, this is of 1st May 2017. DGCA approves AME training institutes to impart ab initio training in the field of aircraft maintenance. The National Civil Aviation Policy clearly states MOCA will endeavor to have the flight training schools, aircraft maintenance engineering schools, and other training schools providing training in the aviation sector registered, recognized under law or as a part of an approved vocational educational course or as training partners approved by the National Skill Development Corporation or the Sector Skill Council. So it doesn't mean, my lord, these things were approved even in 2017, my lord. Endeavor was going to be made. In line with the National Civil Aviation Policy, the University Grants Commission, in consultation with Ministry of Civil Aviation, has introduced a BSc Honours course in aircraft maintenance, and a template for model syllabus has been published, which is available in the UGC website. And at the bottom it says, this supersedes public notice dated 8 March 2017. Now the model syllabus, my lord, is at annexure number 3. Template, it says template, my lord. This is at page number 21. This template was only issued on 16 January 2017, my lord. The Ministry of HRD, my lord, at page 21.
Yes.
The Ministry of HRD, in a meeting held on 22/6/2016 with the Secretary Civil Aviation and DGCA, pertaining to introduction, my lord, of BSc course in aeronautics engineering in various universities, decided that a template of syllabus of this course may be designed. Being an important domain of knowledge, UGC has got the model syllabus for BSc Honours Aircraft Maintenance and framed following the choice-based credit system guidelines. This template of syllabus is being posted on UGC website for the perusal of institutions of higher learning. So this was only issued in 2017, my lord, and from page number 22 onwards, these subjects, the various subjects are there, my lord. But I will not go through all of those things, my lord, at this stage. Now, if your lordship will turn to page number 34. My lord, this is an annual report of the UGC, my lord. An annual report of the UGC, and in this annual report, my lord, at page number 48, it starts at page number 34. The relevant part is at page number 48, my lord.
Yes.
My lord, will see the bottom on 3rd October 2018. 3 October 2018, my lord.
Yes.
The commission informed all the universities, colleges that UGC has designed curricular structure for bachelor level degree program in aircraft maintenance as a way of encouraging universities to come forward and offer this program on their campuses under choice-based credit system introduced by UGC. The syllabus is available on the UGC website, so and so, for implementation by all the higher educational institutes. However, this is very important, my lord. However, the universities are requested to obtain the approval of the Directorate General of Civil Aviation before adopting the syllabus, as DGCA is a statutory body responsible for laying down standards and regulations for air safety and airworthiness standards. It is mandatory for all the universities to display the certificate of approval on their websites for information and awareness of the students seeking enrollment in the course. So, my lord, this course can only be offered, my lord, if approval is taken from Directorate General of Civil Aviation. Now, in this respect, my lord, the petitioner had made an RTI application, my lord, to the Directorate General of Civil Aviation, my lord. And his RTI application, my lord, is at the relevant portion of his RTI application, my lord, is at page number 55. Sorry. At page number 54, my lord.
UGC is a party here?
No, UGC is not a party, my lord. But anyway, my lord, I will, because, my lord, these documents are relevant, my lord, at page number 54. My lord, towards the bottom, my lord, it says like this: certified through copy in PDF of the list of institutions. So these are the description of information sought, my lord. He wanted to apply for certified through copies in PDF of list of institutions adopting the syllabus of Bachelor of Science in Aircraft Maintenance under the approval of DGCA during the academic year 2018-19, that is July 2018 to May 2019. Second, does Singhania University have an approval of DGCA for imparting Bachelor of Science in Aircraft Maintenance during the academic year 2018 to 2019? That is the year the degree was offered, was given to the respondent number 5, my lord. That is July 2018 to May 2019. Now, my lord, since no answer was forthcoming from him, originally, it did not come. So he went on appeal, and my lord, the relevant appeal reply is at page number 59, my lord. Page number 59, my lord, towards the bottom, findings and order, my lord. Appeal in PDF was received with this RTI appeal details. Ongoing through the records. Point number 1. DGCA has neither provided nor issued any syllabus for Bachelor of Science in AME maintenance to any university or UGC in the country for adopting syllabus and offering such degree in the country. DGCA has not approved any institute to offer undergraduate degree/diploma. Point number 2. DGCA has never approved to Singhania University to offer Bachelors of Science in Aircraft Maintenance BSc AME during the academic year 2018 to 2019 until date, if applicant is not satisfied with the reply of the first appellate so and so, my lord. So, with respect to this degree, my lord, the first part of the degree which he had received from Nimrana, my lord, as was mentioned in that public notice, my lord, till 2017 it was never recognized, that course. Now, Singhania University, my lord, he had done in 2018-19. Again, this RTI reply says, my lord, that Singhania University was never recognized. So, based on this, my lord, we are saying that his degree was not a recognized degree.
Alam, you may go. What are the degrees which you have just shown me that he has obtained?
My lord, we'll come to page number 65, my lord.
65.
65
Of the same,
of the affidavit filed by the respondent number 5, my lord, sorry.
65.
Yes, this is the affidavit in reply of the respondent number 5.
Starts from 62, no, 68, 61. No,
Yes,
60 also.
it starts from 61, my lord. These are the mark sheets. It starts from, in fact, it starts from 59, my lord.
What is the full form of AME?
My lord, Aircraft Maintenance Engineering, if I've not mistaken.
AME, okay. School of Engineering Technology.
Yes.
Of which place?
This was in Nimrana, my lord.
Who is that?
So this was, he had initially done one course in Nimrana, the AME course, my lord, at page 65.
This is in Delhi.
Nimrana is in Rajasthan, my lord.
No, below the page, you see that some Dwarka, Delhi and all that. What is this?
My lord,
Page 60?
page 60, yeah.
Below the page.
Dwarka, New Delhi, and all of that is written, my lord. Perhaps this one is the issuing authority, my lord, Director General of Civil Aviation. This is the mark sheet, my lord.
But this, it says approved by Director General of.
No, so let me put it like this, my lord. Let me explain. My lord, till this was, it appears to be approved by the Directorate General, my lord, of Civil Aviation. Appears to be, my lord. But this was in 2012, my lord. In 2012, this was never, in 2012, it was not a recognized course. As your lordship will remember, the public notice itself clearly says it was not a recognized course.
Second, third, fourth, fifth semester.
Fifth semester.
5 semesters. Then Nimrana.
Nimrana. He had done 5 semesters at Nimrana for 3 years till 2012. And in 2012, my lord, the course was not recognized by UGC. And then in 2019, my lord, he did another 6 months course at page 67, my lord. And this was from Singhania University. Which was also from Rajasthan.
Yes.
So basically, my lord, with respect to the degrees, this is our submission, my lord. 2012, he obtained this degree from Nimrana, but then till 2017, my lord, this course was never recognized. And thereafter, in order to regularize his course, what appears to be the case is, my lord, he went to Singhania, because 2017 it became recognized. And this mark sheet was obtained by him from Singhania, which is at page 67. And Singhania University, as per the RTI reply, was never approved.
So how many institutes are involved?
In the aircraft maintenance, my lord? That part I'm not, my lord, I have no instructions.
No, I mean, according to you, the petitioner has, the respondent number 5,
Five, my lord.
has done his 6 months course
Yes,
in Singhania.
yes.
Before that, 5 semester from
Nimrana.
Nimrana. And as per the RTI appeal reply, DCG has never approved Singhania University to offer Bachelor of Science. (2018-19)
2000
until date.
Yes, 2018-19 is because that was the year, my lord, he had received his degree from Singhania. And with respect to the first part, my lord, the Nimrana, which he had received in 2012, my lord, from the public notice dated 8 March 2017, my lord, it's quite clear that till 2017 that course was never recognized. They are not recognized as degree or diploma, my lord. They are probably recognized only as a training program. At page number 18, my lord, of the affidavit dated 26/6/24. Yes, it's a training course, my lord. If your lordship will see the degree certificate also, my lord. If your lordship will come back to the page number 65. 65. Your lordship will see the third line. This is to certify that Mr. Lalrin Omakhyangte, son, daughter of Mrs. Lalswan Omakhyangte, has successfully completed 3 years full-time AME training course, my lord. It's never a degree. Of course, this training course at that time was approved by the Director General, and my lord, the courses are mentioned in the bottom. The training program equivalent to ICAO Type 2 Standards Comprehensive cover avionics stream in 6 distinct semesters, which include planned classroom instructions and on-the-job practical training to cover routine maintenance, drag rectification, component replacements, etc., coverings, avionics system of Fokker F-27-200 aircraft and Fokker F-27-500 aircraft with RR Draft 552 7R engines from School of Aeronautics, Nimrana. So it was always a training course, my lord. It was never a degree. And it is because of this reason, my lord, at page number 18 of the affidavit dated 26/6/24.
Yes.
So, my lord, that is with respect to the with his degree, my lord. Now, my lord, considering the first part, and my lord, I'll just, if your lordship will appreciate, will check, my lord, additional affidavit dated 12/10/2023, which we had also submitted, my lord. Affidavit dated 12/10/23, my lord.
Yes.
If your lordship will kindly turn to page number 27.
27.
27. This was from the RTI reply we received from the respondent numbers 1 to 4, my lord. This is the only degree he received, and this was from Singhania, my lord, Bachelor of Science. This is to certify that Dalrin Oma Khiangte, son, daughter, wife of son of George V. Khiangte, is hereby awarded the degree of science in AME, Aircraft Maintenance Engineering, after having passed the examination for the said degree held in 2018. Now, my lord, this was the only time he was awarded by a degree by any institute, and this was by Singhania University, my lord. And your lordship knows, already placed, my lord, that Singhania was never recognized. And this was issued on 10 January 2020. So, my lord, that is with respect to that degree, my lord. Now, my lord, unless my lord has any more queries in this aspect, my lord, I'll go back to the first issue, my lord, that is that overage, my lord. My lord, the submissions, the Supreme Court judgments, my lord. So, my lord, the first case that we would like to cite, my lord, this is a full bench judgment of the Bombay High Court, my lord. This was reported, this was in Maharashtra Public Service Commission versus Sunil Santosh Pawar, my lord. Reported in 2019, 1 Maharashtra Law Journal 447. Yes, Lordship, I have provided. Maharashtra Law Journal. So, my lord, this is a full bench judgment, and the question involved in this case, my lord, if your lordship will come to page number 451, my lord. (451) at the bottom, paragraph number 2. Paragraph number 2. Main issue involved in the reference. In Dubewar Supra, the division bench comprising of Sri S.A. Boat J, as his lordship then was, and Sri A.B. Chowdhury J, was concerned with the petitioner who had applied for selection to the post of reader. The maximum age limit prescribed for selection was 35 years, as on the last date for receipt of applications. The petitioner Dubewar was 45 years, 8 months, and 2 days old, as on the last date. However, she contended that she was entitled to cumulative age relaxation by 13 years, my lord, just like our petitioner here. She relied on certain rules, executive instructions, which provided 10 years age relaxation in favor of physically challenged applicants and 3 years age relaxation in favor of reserved category applicants. In the absence of any indication, my lord, this is exact question that we have in our case. In the absence of any indication in the rules, executive instructions as to whether age relaxation to be construed as cumulative benefit, as contended by the petitioner Dubewar, the division bench held that age relaxation will have to be construed on a non-cumulative basis. Therefore, the petitioner Dubewar was held entitled to age relaxation by maximum 10 years and not 13 years as contended by her. The reasoning of the so-and-so, I'll not read, my lord. And the second one, number 4, my lord. In Patil, so these are the two conflicting judgments in the Bombay High Court. In Patil Supra, the division bench comprising of Sri B.R. Gavai J and Sri Indira K. Jain J was concerned with an application, Patil, who had applied for selection to a post for which the maximum age limit prescribed was 35 years, as on the last date of receipt of applications. The applicant Patil was around 43 years old as on the last date. However, relying upon certain rules, executive instructions, Patil contended that he was entitled to age relaxation of 5 years since he was already in government service and an additional 5 years since he belonged to the reserve category. The rules, executive instructions do not provide for such age relaxation. However, there was no indication in the rules, executive instructions as to whether such age relaxation was to be construed cumulatively or non-cumulatively. The division bench, however, upheld the view taken by the MAT that the age relaxation be cumulatively construed. And then the reasoning is provided. And then, my lord, will come to paragraph 7. Yes, my lord. Citation. And my lord,
5 years because of government employment
yes,
and 5 years because of reserve category.
correct.
So where is the controversy?
So there were two conflicts, my lord. So, my lord, the
The
first
first one said only non-cumulative.
correct, Dubewar said non-cumulative. And then, my lord, there was another case, Patil, who had said
Patil was
cumulative.
cumulative.
Correct, my lord.
So then the larger bench was constituted.
Correct, the full bench
Okay.
was constituted. And, my lord, the reference before the full bench is at paragraph 8, my lord.
Yes.
Therefore, the main issue involved in this reference is whether, in absence of any indication in the rules, executive instructions, provisions for age relaxation should be construed on cumulative or non-cumulative basis in respect of applicants who are covered under more than one category for which age relaxations may have been provided. And now, my lord, I'll take your lordship to the reasoning. My lord, at paragraph number 26. My lord, even though it's slightly long, my lord, because I'm relying on the reasoning in this case, my lord, if I may be allowed to read, my lord, paragraph number 26.
Yes.
As noted earlier, the main issue involved in this reference is whether, in absence of any indication in the rules, executive instructions, provisions for age relaxation should be considered on cumulative or non-cumulative basis in respect of applicants who are covered under more than one category for which age relaxation may have been provided. 27. Since the issue squarely relates to reservation, which takes within its sweep exemptions, concessions, or relaxations in matters relating to employment or appointment to any office under the state, the issue will necessarily have to be considered in the context of the constitutional provisions in Article 14, 16, and 335. Article 14 of the Constitution, which enshrines the guarantee of equality to all persons, provides that the state shall not deny to any person equality before the law or the equal protection of the law within the territory of India. In the specific context of equality of opportunity in matters of public employment, Article 16.1 provides that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Article 16.2 of the Constitution is even more specific and provides that no citizen shall, on grounds only of religion, race, caste, sex, descent, place of birth, residence, or any of them, be ineligible for or discriminated against in respect of any employment or office under the state. Article 16.3 is not very relevant for the present purposes, but Article 16.4 is extremely relevant and provides that nothing in this article shall prevent the state from making any provision for the reservation of appointment or post in favor of any backward classes or citizens which, in the opinion of the state, is not adequately represented in the services under the state. For the present purposes, Articles 16.4a and 16.4b are not very relevant. In Indra Shoni, the Constitution bench, on examining the meaning and content of the term reservation in Article 16.4, concluded that the term includes not only reservation simpliciter or reservation proper, but also all other supplemental or ancillary provisions, as also lesser types of special provisions like exemptions, concessions, preferences, and relaxations, consistent, no doubt, with requirements of maintenance of efficiency of administration. The admonition of Article 335 of the Constitution. The relevant discussion on the aforesaid aspect is found at paragraph 743 of the majority opinion in Indra Shoni Supra, and the said reads thus: before we answer this question, it is well to examine the meaning and content of the expression reservation. Its meaning has to be ascertained having regard to the context in which it occurs. The relevant words are any provision for the reservation of appointments or post. The question is whether the said works contemplate only one form of provision, namely reservation simpliciter, or do they take in other forms of special reservations like preferences, concessions, and exemptions. In our opinion, reservation is the highest form of special provision, while preference, concessions, and exemptions are lesser forms. The constitutional scheme and context of Article 16.4 induces us to take the view that larger concept of reservations takes within its sweep all supplemental and ancillary provisions, as also lesser types of special provisions like exemptions, concessions, and relaxations, consistent, no doubt, with the requirement of maintenance of efficiency of administration, the admonition of Article 335. There is no reason why such a special provision should not be held to be included within the larger concept of reservation. It is in this context that the words, any provision for the reservation of appointments and posts, assume significance. The words any and the associated words must be given their due meaning. 31. The Constitution bench in no uncertain terms holds that the concept of reservation, which includes inter alia relaxations, may be provided under Articles 16.4, consistent no doubt with the requirement of maintenance of efficiency of administration, the admonition of Article 335. Therefore, reference to the scope and import of the provisions of Article 335 becomes necessary. Article 335 of the Constitution provides that the claims of the members of SC and ST shall be taken into consideration consistently with maintenance of efficiency and administration in any appointments to services and posts in connection with the affairs of the Union or State. The proviso inserted by the Constitution 82nd Amendment Act 2000 provides that nothing in this article shall prevent in making any provision in favor of members of SC, ST for relaxation in qualifying marks in any examination or the lowering of standards for evaluation for reservation in matter of promotion to any class or classes of services or posts in connection with the affairs of the Union or of a State. The seeming overlap between Article 16.4 and Article 335 has been explained by the Constitution bench by holding that the provisions in Article 335 operate as a limitation on the powers vested in the state to provide for reservation or relaxation under Article 16.4, even though 16.4 makes no specific reference to Article 335 or raises the question of maintenance of efficiency of administration. In M. Nakraj, another Constitution bench explained that the condition regarding maintenance of efficiency of administration imposed by Article 335 is a constitutional limitation on the exercise of discretion vested in the state to provide for reservation and relaxation in public employment. My Lord, these things go on, my Lord, but I will take your Lordship, my Lord, to paragraph 48. One minute, my Lord.
Anything in particular you would like to show me?
No, my Lord,
there are straight to the operative portion.
My Lord, I'll take your Lordship, because there are some parts, my Lord, which are important, but I'll take your Lordship to a Supreme Court judgment on those points, my Lord. I think that will be easier. But, my Lord, what the court had eventually done, my Lord, was, if your Lordship will see the ultimate result, my Lord, at
It
page...
cannot be cumulative and you have to exercise your option.
Correct, my Lord.
That's
That is
what
basically
is-
the answer, my Lord. At page number... in the last page, my Lord, at paragraph number 84. It says like this, my Lord. In the absence of any indication in the rules, executive instructions, the provisions for age relaxation cannot be construed on cumulative basis in respect of applicants who are covered under more than one category for which age relaxation may have been provided. Rather, such provisions will have to be construed on a non-cumulative basis. This means that if an applicant, for example, belongs to the SC category for which age relaxation up to 5 years is provided, and also belongs to ex-serviceman category for which the age relaxation up to 3 years is provided, then such applicant, in the absence of any indication in the rules, executive instructions will be entitled to cumulative age relaxation up to 5 years or up to 3 years. The applicants who are covered under more than one category for which age relaxation may have been provided in the absence of any contrary indication in the rules, executive instructions will have a choice to opt for benefit of age relaxation which suit their interest. Then, my Lord, finally it overrules Dubewar. But, my Lord, there were some points here, my Lord, which talks about
See, that's why I asked you.
yes,
They've stressed on one point.
yes,
In the absence of any rules,
yes, to the contrary.
to the contrary, if the rule provides specifically that you may go for two benefits,
Correct,
then there's nothing,
Yes.
this rule may, this authority may not apply.
yes,
But if it doesn't,
yes,
then this authority is very clear, says that in absence of anything
yes,
in the rules, you have to choose one.
you have to choose one.
And you may opt this or that.
Correct,
Supposing you have 5 years in one and 3 years in one,
yes,
obviously you may go for 5 years,
correct.
depending on your requirement.
My Lord, in this case also, yes, that is correct. And the court had given some examples, my Lord, where where cumulative benefits can be given, my Lord. And this is also, I think it can be, I can point to the office memorandum that my learned, the other side had relied on, my Lord, where it mentions, if your Lordship will come to paragraph 42, my Lord. Paragraph number 42. Says like this, my Lord. Several sets of rules, executive instructions, enacted or issued by the central government or even the state government were brought to our notice. In most of such rules, executive instructions, there were clear indications when provisions relating to age relaxations were intended to be construed on cumulative benefit basis. For example, some rules executive instructions specify that physically challenged persons belonging to SC/ST category will be eligible for age relaxation of 10 years over and above the age relaxation of 5 years admissible to them as SC/ST. My lord, these kind of rules that they have mentioned, my lord, these are part of the affidavit they had submitted by the respondent number 1 to 4, my lord. If your lordship will.
Yes.
My lord, if your lordship will see that memorandum, that set of memorandum they had relied on, my lord, which is at page number 62 of their affidavit in reply, my lord. Page 57 it starts.
Of the counter affidavit.
Of the counter affidavit, my lord.
Page 50.
Now,
Page number?
it basically, my lord, theirs basically start from page 57, and the relevant portion is, my lord, at page number 59. Now, my lord, the reason I'm taking your lordship to this page is because if your lordship will see 7.1.
Yes.
Meritorious sports person, my lord. Relaxation in upper age limit up to maximum of 5 years if you are a meritorious person, my lord, because this has clearly indicated, my lord, when it can be held cumulative, my lord. 10 years in the case of those belonging to SC/ST. So 5 plus 5, 10. Now another example, my lord, would be if your lordship will come to the next page, my lord, at serial number 9.1.
Hmm.
9.1. Disabled defense personnel will get relaxation upper age limit up to 45 years, 50 years in the case belonging to SC/ST. So this is the kind of thing that has been mentioned at paragraph number 42, my lord, of this judgment.
Then what happens in those cases?
So in those cases, my lord,
Permissible.
yes, those are the only cases according to this judgment it would become permissible.
So in this case, if at all applicable, 5.2 can be
Maximum,
adopted,
my lord, maximum.
and which is a maximum of 5 years only.
Yes, 5 years.
And having availed this 5 years, one cannot go for the ST benefit.
That is my submission, my lord. And to strengthen this point, my lord, there is one Supreme Court judgment that I would like to take your lordship to, my lord. This was reported in 2018. 2018-11 SCC 352.
2018-11,
352, my lord.
352. Paragraph numbers?
My lord, paragraph number 3. Then paragraph number 12. And paragraph number 21 onwards, my lord. 20 onwards.
20 onwards.
Yes. Findings. Anyway, my lord, I will not read all of those relevant paragraphs that I have mentioned, my lord. I've already pointed out the paragraphs, my lord. But the facts in this case, my lord, is like this. At paragraph number 3, my lord. The Rajasthan Public Service Commission issued an advertisement dated 14/10/2010 inviting applications for selection on various posts of constables. On 25/10/2010, another advertisement was issued by the Rajasthan Public Service Commission for selection on the post of Sub-Inspector of Police. The selection process for the post of constables as well as post of Sub-Inspector of Police comprised of the different stages. During process of selection, the state government issued a circular dated 11/5/2011 providing that candidates of SC, SBC, SC, ST, irrespective of whether they have availed of any concession, including relaxation in age, shall be migrated against open category vacancies if they have secured more marks than the last candidate of open category. My lord, I've read this, but my lord, I don't want to put your lordship. But the reason I'm citing this, my lord, is because as clearly admitted by the respondents, they have admitted, my lord, that this post that we are fighting for is an unreserved post. It's not a reserved post, my lord. It's an unreserved post. It is admitted by them, my lord, in their affidavit. In fact, the respondent number 5 in his affidavit in opposition at serial number 1 of his submission, my lord, at page number 4, he had stated that this is an unreserved post. So the submission that I'm trying to make using this Supreme Court judgment is, my lord, because this Article 16(4), my lord, is an enabling provision. It's an enabling provision unless there is a clear indication from the rules, my lord, that says that an ST, someone who has availed SC, ST, can also come within the reserve, can also occupy the unreserved seat, my lord. Once you have availed of any benefit from SC, ST, my lord, you cannot be considered for the post of a unreserved seat. That is the point I'm trying to make using this Supreme Court judgment. My lord, the respondent number 5.
No, please come again. If you avail for...
My lord, the respondent number 5, let me try.
No, what did you just say? If you avail for the benefit under the SC/ST,
yes,
you cannot avail for what?
Once a person, my lord, avails benefit, any type of benefit like concessions, age relaxation under the ST,
yes,
then he cannot be considered for filling up post if the post is an unreserved post. Unreserved post means if the post is for a general, for everyone, my lord. Once an ST person, my lord, takes benefit of let's say a quota or something like that, my lord, some benefit. That's what this Supreme Court judgment says, my lord, that once you have taken benefit, then you cannot be considered for an unreserved post. You can only be considered for a reserve post. My lord, let's say UPSC, my lord. UPSC, my lord, let's say they have 50 posts. And out of these 50 posts, my lord, they come up with this number. They say that 10 posts will be for reserve category. So there's a clear indication that 10 posts is for reserved and 40 posts is for non-reserved posts, my lord. And now let's say someone, my lord, gets age relaxation under the ST/SC. That person cannot be made to occupy the rest of the post. That's what this judgment is trying to say. I'm using this example, my lord. The facts here in this case is different, but
no, this is based on a different criteria altogether, which you just read, paragraph 3.
My lord, will come to paragraph 49, my lord. The conclusion is quite clear.
If one gets more marks than the last general candidate, he or she cannot avail the benefit given by that reserve category. This is what it says.
No, my lord, will come to paragraph 49, my lord.
Because you have clearly qualified yourself.
Correct.
You have scored more marks than the last general category.
The circular says that, my lord. This case, I'll give your lordship the brief facts. What happened was a circular
But in your case, there's only one post.
Only one post, which is an unreserved post.
Unreserved post.
Yes.
So anybody can contest.
But they cannot take benefit. They cannot take benefit of ST/SC reservation or ST/SC concessions for filling up that unreserved post, my lord. That's what I'm trying to say.
Why not?
because the post is not for reserve post. It's for everyone, my lord. It would result in an unlevel playing field, my lord. My lord, comes to paragraph number 49 of this case.
Okay.
Sorry, my lord, 1 minute. Yes, page 49, my lord. It says like this. In view of the foregoing discussion, we are of the considered opinion that the candidates belonging to SC, ST, BC who had taken relaxation of age were not entitled to be migrated to the unreserved vacancies. The state of Rajasthan has migrated such candidates who have taken concessions of age against the unreserved vacancies, which resulted displacement of a large number of candidates who were entitled to be selected against the unreserved category vacancies. My lord, in our case, the respondent number 5 has taken the benefit of that ST. He's saying that ST 5 years, additional 5 years, my lord. Our submission is, my lord, supposing you can take that benefit, that you can have 2 concessions. In that case also, since this post is an unreserved post, he cannot be considered for placement in this post. And my lord, there is one more Supreme Court judgment which has made it more clear. My lord, this new Supreme Court judgment I have is of 2019, 7 SCC 383, my lord.
No, just a minute.
Yes.
Let us try to understand this judgment first properly.
My lord, will come to paragraph 12 of this judgment. The issues are given there, my lord. You know,
Yes.
my lord, at paragraph 4, the issues are given. And in this case, my lord, basically what the Supreme Court says is once you have taken the benefit under that are only allowed for a reserve category, reserve candidate, you cannot be considered for an unreserved post. Basically, that is what I am trying to say, my lord. And since Article 16.4 is an enabling provision, which means, my lord, Article 16.4 is, unless there is a law, there can be no presumption under 16.4, my lord. There has to be a specific provision which allows for such benefit under 16.4, because it's an enabling provision.
Yes, what is the other judgment?
My lord, the other judgment is reported in 2019-7 SCC 383. And this is directly connected to one office memorandum, my lord, which I have also provided, because in this Supreme Court judgment, it has relied on this office memorandum, my lord. I think
Yes, what are the relevant paras?
my lord, I'll read only paragraph 13. Paragraph number 13. My lord, I'll read, my lord. The state government, in exercise of its powers conferred under Article 309 of the Constitution of India, made rules of 1967 vide notification dated 10/10/1967. As per sub-rule 2 of Rule 8, the appointing authority has been given powers to relax age limit in favor of the candidates belonging to SC, ST and SCBC in favor of women candidates to the extent indicated therein. The Ministry of Personal Grievance, Public Grievances and Pensions, vide Office Memorandum dated 22/5/1989, formulated a policy in tune with Article 16.4 of the Constitution of India. My lord, this memorandum I will provide to you. This memorandum I'll provide to your lordship. In tune with the Constitution of India, which enables the state government to provide for reservation for the category of persons belonging to backward classes. Thereafter, the Ministry of Personal, Public Grievances and Pensions, vide Office Memorandum. I'll give to the other side also, my lord. Vide Office Memorandum dated 1/7/1998 clarifies the earlier OM dated 22/5/1989. Now, this Office Memorandum dated 1/7/1998, my lord. To the other side also, my lord. I have provided to your lordship, my lord. Now, this Supreme Court judgment clearly says that this office memorandum is in line with Article 16.4, my lord. It has made it very clear. Now, this office memorandum, my lord, says like this. The undersigned is directed to refer to this department OM number 3601121388 established SCI dated May, my lord, this is the same one referred to in this paragraph, May 22nd, 1989. And to clarify that the instructions obtained in the OM apply to all types of direct recruitment, whether by written test alone or written test followed by interviews or by interviews alone. OM dated May 22, 1989, referred to above, and the OM number 36012/296, established dated July 2nd, 1997, provide that in case of direct recruitment, the SC, ST, OBC candidates who are selected on their own merit will not be adjusted against reserved vacancies. In this connection, my lord, this is important, it is clarified that only such SC, ST, OBC candidates who are selected on the same standard as applied to general candidates shall not be adjusted against reserved vacancies. In other words, when a relaxed standard is applied in selecting an SC, ST, OBC candidates, for example, in the age limit, experience, qualification, permitted number of chances in written examination, extended zone of consideration, larger than what is provided for general category candidates, etc., the SC, ST, OBC candidates are to be counted against reserve vacancies. Such candidates would be deemed as unavailable for consideration against unreserved category vacancies. Now, my lord, This is exactly what I was trying to say, my lord. Since this post that we are fighting for, my lord, is an unreserved post, once you take the benefit of SC, ST, my lord, you cannot be considered for this post. This office memorandum I'm providing at this stage only because, my lord, it comes with this Supreme Court judgment.
Yes.
So, my lord, it would amount to blowing hot and cold, my lord, basically. Now, my lord, that point which I had mentioned regarding the statement of the respondent number 5, that it is an unreserved post, my lord, is in their affidavit. My lord, I'll just quickly take your lordship to their affidavit in opposition of the respondent number 5. Page number 4, my lord. My lord, in the second line from page number 4. It may be noted that the post of Superintendent Group B, which was advertised, is an unreserved, and this post is governed by the NITs. So, my lord, once they have taken, if they want to, they cannot take STSC because this is an unreserved post. That is basically my submission, my lord.
What is the response of the NIT?
My lord, NIT is silent on this unreserved. If I have not mistaken, my lord, I think my learned friend can.
The advertisement itself says it is an unreserved post.
Advertisement it says, yes.
Advertisement itself.
So departmental candidate, my lord, they give relaxation. I mean, that aspect, my lord, we might not be able to say much, my lord.
What you mean to say is that if you contest for an unreserved post,
Yes,
being an ST, you cannot say that give me 5 years
correct.
relaxation.
Yes.
If you take that benefit, then what happens?
My lord, you can take that benefit only if you are applying for a reserve post.
There are two things actually. One is the judgment which you are referring
Correct. That is first.
to. That judgments, in fact, just because you have scored more than the last unreserved category, you should not be placed amongst the unreserved category.
Correct. That, in essence, it's...
Since you have availed, to get to that place, you have availed the benefit of a reserve category. You
Correct.
should remain in your category only.
Correct.
But here's a case, there's only one post, which
Yes.
is unreserved.
Yes.
So all types of category people participate,
Yes.
and for this purpose of this case, one reserve category ST participates.
Yes.
Since he's participating for an unreserved post, he cannot come and say that give me 5 years.
Correct.
So at the outset only you have disqualified him.
Correct.
Had he been 30 or below 30, would have participated, no problem. That way he'll not have to avail for that ST benefit,
Yes.
for age relaxation.
Correct.
But since he was over 30,
Yes.
being an SC, he said, take me in.
Yes.
But he knows very well that this is an unreserved category.
Unreserved category.
So what you say is that he could not have participated
He could not have participated
with relaxation.
with relaxation. He, because, my lord, though he was relaxed once for 5 years, in spite of the first relaxation, my lord, he was still overaged. And so he's taking the benefit of this office memorandum somewhere which says talks of ST categories and all. So he's trying to get 10 years benefit, basically. Firstly, my lord, my submission is Bombay High Court, that full bench, my lord, already talks of cumulative, non-cumulative.
But that issue regarding a reserved category person contesting for the unreserved category, availing that age benefit, that is still not clear. Somehow I find that your judgment
Yes, yes.
is slightly bit
No,
different.
Lordship is absolutely right, my lord. This is not direct. My lord, there will be very less judgments on cumulative, non-cumulative, and this kind of judgments directly on this point, my lord. But the point I am trying to raise is this, my lord. These cases, my lord, they have talked about Article 16.4 at length, my lord. I will not go through all of those things. And it talks of Article 16.4 being an enabling provision. Now, my humble understanding of enabling provision, my lord, is this: that the Constitution gives the right or gives the power, my lord. Let's say power, my lord, not right. The Constitution gives the power to the state to provide reservation to certain categories of people. 16.4, my lord, that is what it says, Article 16.4. Now, this power by the state, my lord, the state can exercise it, or it can refuse to exercise it. If it exercises and gives reservation, my lord, then the reservation will happen. If it does not give any kind of provision or benefit, my lord, then that letter, that Article 16.4, my lord, will remain as it is. You cannot imply reservation under Article 16.4 unless there is an explicit provision. That is what I'm trying to say. And now, my lord, what I'm trying to say in this is, unless there is a spelled out provision, my lord, which says that this post can be filled after you get a reserved, after you get all the benefit of reservation, or after you get all the benefit of 16.4. Unless the state or the NIT makes a law to that effect, that says that unless, even if you get reservation on all of these things, you can enjoy, you can have these things, my lord, you cannot imply that right. That is what I'm trying to say, my lord. You cannot imply the right, because relaxation is a 16.4. It comes under Article 16.4.
Okay.
And my lord, this office memorandum, the last part, my lord, let me just try to impress your lordship again one last time, my lord. The last part: such candidates would be deemed as unavailable for consideration against unreserved vacancies.
So that I understood.
My lord, I think
But going back to your earlier thing, at page 83 of the advertisement,
yes,
there's a saving clause.
yes.
It says, nothing in this rule shall affect reservations, relaxations of age limit, and other concessions required to be provided for the candidates belonging to SC, ST, other OBC, ex-servicemen, and other special categories. So this is a part of the rules.
This is, let me see, my lord.
What you are saying is that if it's an unreserved category,
Yes,
everyone can participate. You include.
my lord, in our present case, he could not have taken that benefit simply because this is an unreserved post. Present case, he could not have taken that benefit simply because this is an unreserved post. That is basically what I'm trying to say, my lord.
Okay.
I'm trying to say, my lord.
Okay. I think that's your case.
And my lord, finally, there's
Your case.
And my lord, finally, there's one last judgment as a block. Therefore, in view of the principle laid down by the Supreme Court, recruitment rules of assistant registrar in NIT will prevail over the office memorandum dated 27/3/2000.